Major breaking news. We have a U.S. Supreme Court case in the case of Moore versus United States. Now, this is an important case for people that love freedom. It's not specific to guns, but it actually could relate to guns because this deals with the ability of Congress to step up and tax you into oblivion. The good news is, even though the Supreme Court in this case of Moore ruled against the specific taxpayer, we'll get to that in one moment, the good news is they've set some very strong precedents that are going to make it impossible, in my view, with this Supreme Court to get like a wealth tax through, which is the sort of thing that Elizabeth Warren wants to do, and we don't ever want a wealth tax because it always starts with the richest of the rich, like the income tax, and next thing you know, it attacks all of us, just like the income tax and just like Congress, just like the taxing authorities. Let's break this all down and what this case of Moore versus the United States means for you and our freedom in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the best-selling new book, Israel Disarmed, What the 10/7 Attacks Teach Americans About the Right to Bear Arms. We must learn from the mistakes of others. A lot of detailed information in that book, Israel Disarmed, about our Second Amendment and the mistakes that the Israelis made in not adopting our Second Amendment, even though there was discussion of doing so. Big mistake by the Israelis. We must always learn from the mistakes of others so we don't give up our rights here in any respect, including our constitutional rights, including our Second Amendment rights, and the right to defend ourselves through the right to bear arms. All right, folks, here's the story. Major Supreme Court case, not specific to the Second Amendment, but it's very important to understand these cases because remember, it's the same justices that are going to be issuing decisions about the scope of the Second Amendment and our right to keep and bear arms are the same justices that decide other constitutional cases. So it's very helpful to study what this Supreme Court does when they decide other cases involving the interpretation of the Constitution. How do they think and what they mean? And this is an example of a really happy example, I should say, of one thing that we in the Second Amendment community are very lucky about that is not the case for, let's say, other components of the conservative movement, such as those individuals and those groups and those folks that are fighting to defend our right to property, which obviously is extremely important. But here's why I say that. If you look at the decision in Moore versus the United States today, the Supreme Court decided this case, and the question was whether or not Congress had the constitutional authority to impose taxes on certain American-owned companies that were operating overseas for what were called sort of undistributed income that were kept in the companies. And again, why this is so important is 2017, as part of the Tax Cuts and Jobs Act, Congress imposed a one-time backwards-looking tax on American shareholders of companies that these Americans held ownership interest in American-controlled foreign corporations. And you'll see why this is so important in the Second Amendment in 1 second. The idea was that there were trillions of dollars of undistributed income that had been earned by these companies but had not been paid out to the Americans living in the United States. And Congress wanted to tax this money even though the Americans had never got the money. They had earned the money kind of through the corporations overseas, but they never got the cash distributions. So the litigation here was whether or not under the Constitution, did Congress have the authority to tax Americans for cash they never actually received, for property they never actually received, but was technically earned by companies that they had an ownership interest in overseas. And the Supreme Court, and this is what's so important, listen carefully, the Supreme Court said that because the existing Supreme Court precedent, because of that precedent, the Supreme Court and Congress and the IRS, allowing for taxes to be imposed on partners and shareholders of companies that had not distributed income that had been earned by those partnerships or those companies, that precedent allowed Congress today, as part of the 2017 mandatory repatriation tax, to follow that precedent and thus to allow the taxation to legally occur on Americans in America, even though the money was earned overseas and even though the money never came back to America and was never paid to them. Now, the reason why this is very important to understand is for twofold for the Second Amendment, okay? The first thing is that it really goes to show you how we are lucky in the Second Amendment movement that there's no terrible barnacles of terrible Supreme Court precedent on the books that we, to advance our cause, if you will, have to overturn. If you think about it, for example, from the pro-life position, if you're pro-life and you want to get rid of abortions in America, you first had to get rid of Roe v. Wade. And then after you got rid of Roe v. Wade, then you could try to play some offense, if you will. Here in the Second Amendment space, we don't have years and years and years of anti-Second Amendment Supreme Court precedent that we either have to distinguish or get rid of or overturn or any of that stuff. So we're very, very lucky that we're kind of the Supreme Court is sort of writing on a blank slate without having to overturn a bunch of precedents. Likewise, here, the fact is that the Supreme Court today, in the Moore case, relied upon long-standing Supreme Court precedents throughout the 20th century and Congress's sort of actions and traditions of how they operated when you're dealing with unrealized income or income realized by an entity, but not specifically by the owners of the entity or the partners of the partnership. It's another example how those barnacles that built up on restrictions on private property and freedom and property and the ability to earn a living and labor costs and all these things, these barnacles that built up over the last 100 years are now today used against, for example, taxpayers and owners of property because of those barnacles that have built up. And I'm guessing that if the Supreme Court did not have all these precedents to basically say, well, we're going to rely on these precedents, they might have decided this case a little bit differently with respect to this particular taxpayer. So with that said, even though this taxpayer in Moore lost and has paid the taxes and won't get a refund, here is the good news. The good news is it's pretty clear that this Supreme Court, in issuing this ruling, has made it very clear that they are not going to sign off on a wealth tax of the sort of thing that somebody like Senator Elizabeth Warren from Massachusetts would want. Remember, what she wants is to set a precedent. It always starts off with the richest of the rich, right? So the income tax started off taxing just the richest 2% of Americans. That's it. Just the richest 2%. That's all we want to tax. Now, of course, it taxes all Americans. All Americans are subject to the income tax, no matter how wealthy you are. Okay, it always starts off with the richest, and then it comes down to everyone else. Be very careful of that strategy of the anti-freedom loving politicians. So Elizabeth Warren really just wants to tax the wealth accumulated by all this stock ownership in Tesla, in Microsoft, in Nvidia, and the like. So she wants to tax unrealized gains or appreciation, and she just wants to start off with the richest of the rich because how many people are really super rich like that? Just a handful of people, kind of, right? Maybe a few hundred, something like that, okay? Here's the thing, though. Once she sets the precedent, once you set the precedent for being able to tax the wealth of Elon Musk or the wealth of the owners of Tesla or the owners of Nvidia or Microsoft or Meta, you've now set a legal precedent that can then be used to tax all of our wealth, which includes your wealth that you may have in your gun shop, in your gun range, in your auto shop, in your plumbing company, in your law firm, in your accounting firm, in your store, in the restaurant you have an ownership interest in. You see how this game gets played? So they want to start off with just taxing the wealth of certain people, and then of course it will expand out to all of us and tax all of our wealth on top of the income taxes and the sales taxes and the VAT taxes and all these other insane excise taxes and other taxes that they have, property taxes, and you get the list better than I do. All right. So the good news, though, is that the Supreme Court made it clear that that is not going to be allowed. But before I get to why I say it's not going to be allowed, I do want to give you an amusing story, kind of a scary story. Justice Brown Jackson, the one Supreme Court appointee to the bench by Joe Biden, basically says that we should be hands off, meaning the court should be hands off on, guess what? Issues associated with property and taxes because it should be resolved by the ballot box. But you know what that is? That's a euphemism for democracy, which is a euphemism for two wolves and a sheep voting on what to have for dinner tonight. Here's what Justice Brown Jackson said about why she felt the court should really not be involved in basically babysitting and monitoring whether or not these taxes violate the Constitution, which has very specific restrictions, including the 16th Amendment, on taxes and tax funding. Here's what Justice Brown Jackson wrote in a concurrence in today's decision and more. I have no doubt that future Congresses will pass and future presidents will sign taxes that outrage one group or another. Taxes that strike some as demanding too much, others as asking too little. There may even be impositions that, as a matter of policy, all can agree are wrong-headed. However, the Supreme Court decision in Pollock teaches us that this court's role in such disputes should be limited. The remedy for such abuses is to be found at the ballot box and in a wholesome public opinion, which the representatives of the people will not long, if at all, disregard, and not in the disregard by the judiciary of powers that have been committed to another branch of the government. Now, what she's basically saying, of course, is that when it comes to taxing policy, the court should just back off and let the government steal our property, steal our income. And don't forget, your income is the fruits of your labor. You own your body, and when your body generates wealth or income, those are the fruits of your labor. So when they're taxing away and taking away the fruits of your labor, they are essentially taking away parts of your life, because the ultimate form of your property is your body, and you use your body to either make money or build a building or build a house or farm or earn income, whatever it is that you do, those are the fruits of your labor. And here's Justice Brown Jackson basically saying, hey, it's up to the two wolves voting for what to have for dinner against the sheep. That's her approach to democracy, but that's not what the Founding Fathers or the Constitution is about. The Constitution is about putting restrictions on all of these things, especially when it came to federal government tax policy, which has very specific rules about uniformity and direct taxes, which we won't need to get into in this video, but the Moore case gets into quite a bit, and I'll put a link to it, the decision down below, so you can check out the details if you're interested. Now, to tell you why I think there's no way there's going to be a wealth tax is because it's pretty clear we have at least 5 votes to say no can do. If you look at footnote number 2 of the Moore case, and this is why you got to look at the footnotes very carefully, it specifically says that even though they're going to allow this particular tax on this taxpayer in the Moore case, because it's consistent with longstanding precedent of the U.S. Supreme Court to allow these taxes on people that are owners in partnerships and or companies, and this is no different than that. It did specifically say in footnote 2 that there is no way this case should be viewed as signing off on that Congress has the constitutional authority to tax unrealized capital gains in domestic corporations. So again, if you bought Nvidia at $10 and it's now worth, $150, that unrealized gain of $140, you can't be taxed on it until it's sold, is basically what the court is saying here. And it also goes on to say that this case should not be viewed as resolving whether or not Congress can tax an entity and the shareholders or the partners on that entity's undistributed income at the same time to sort of engage in double taxation or tax stock appreciation. So basically, it's pretty clear based on the dissents of Neil Gorsuch and Justice Thomas, coupled with what Samuel Alito and Amy Coney Barrett said in a concurrence about this stuff, and footnote number 2 of the 5-judge majority, it's pretty clear that the court will allow this particular tax to sail through. But if Elizabeth Warren and the Democrats want to have a wealth tax or some sort of other crazy new taxes where we get to tax, our everything associated with our companies, our businesses, your YouTube channels, whatever it is, it looks like that's going to be a bridge too far for the Supreme Court. But again, only time will tell. The Democrats and the liberals and the progressives are always out there trying to expand the scope of government in the name of good government. Supposedly, they think they're smarter than we are, and I don't think that's true, obviously, nor did the Founding Fathers, but that is the world we now live in. So there you have it. I hope this wasn't too geeky. I know it's a little complicated with tax policy, but I thought it was worth discussing because you need to understand all these kinds of cases to really understand the Second Amendment, because it plays a role in the bigger gestalt of how we protect our individual rights. And again, the power to tax is the power to destroy. The power to tax is the power to destroy. Never forget that. All right, folks, there you have it. Don't forget to subscribe. Make sure you follow me at X at 4Boxes Diner. Don't forget to check out my book, Israel Disarmed, on Amazon. And we'll see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.